Welcome back, everyone. Today we're going to turn our attention towards the law and how it affects the correctional system. More specifically, we are going to be reviewing the constitutional protections that are afforded to defendants and later inmates, and how those may differ compared to people who are not currently incarcerated. There are quite a few cases in here that we need to review and discuss, so let's go ahead and get started. As we know, legal proceedings must be in compliance with the Constitution, and anytime those rights are being violated, the courts have the potential to throw a case completely out the window. The first 10 amendments, also known as our Bill of Rights, are the most important to us in terms of protections against police misconduct, improper court proceedings, and ineffective counsel, to say the very least. The only other exception that works on our behalf is the 14th Amendment, which covers due process issues to make sure that the system is in compliance that way. When we talk about constitutionality, remember that the Constitution trumps all other laws in the U.S. If a state law is in violation of the U.S. Constitution, then guess which one will win? The SCOTUS determines whether or not a law is in conflict with the process through the process of judicial review. If the law is in conflict, or if a procedural violation has taken place, then they will rule it unconstitutional. We are going to focus mainly on the First and the Eighth Amendment issues today, since they are the two that are most often used to appeal cases for offenders. But please remember that the Fourth Amendment, otherwise known as the Police Amendment, is used to protect us against unlawful search and seizure. The Fifth Amendment protects us from self-incrimination, which is where our Miranda rights come into play. The Fifth Amendment also protects us from double jeopardy, or the idea that you cannot be tried for the same crime twice. The Sixth Amendment is all about procedural issues, so the right to a fair and speedy trial, impartial jury of your peers, ability to face your accusers, and even the right to counsel. But as I said, we're going to be focusing most of our attention on the First and the Eighth Amendments due to their frequency in being cited on appeal. So we have already discussed the Eighth Amendment briefly in the first lecture of this semester, but remember that this is the Corrections Amendment. We most commonly associate the Eighth Amendment with cruel and unusual punishment, but remember that it also protects us against excessive bail and fines. But when we're discussing the Eighth Amendment in terms of constitutional challenges, we are seeing the challenges most always come from those inmates who are serving prison or jail sentences. If you are simply trying to argue that the length of your prison sentence is too long, it is probably unlikely that you will have your case heard. Look at it from the perspective of the incarcerated. People who are in prisons all day long have nothing to do other than to appeal their cases. It's almost an automatic that inmates will appeal anymore if they can afford to. Sometimes they will file paperwork on their own in an attempt to save the legal costs associated with the appeal. But more often than not, a successful Eighth Amendment appeal will focus on the inmate's characteristics and why punishment is not appropriate in some cases. For example, it's unconstitutional to execute me because I'm too young, or because my But more often than not, a successful Eighth Amendment appeal will focus on the inmate's characteristics and why punishment is not appropriate in some cases. For example, it is unconstitutional to execute me because I'm too young, or because my IQ level is too low, or it's almost borderline, for instance. However, inmates have other options to gain access to the courts without having to file a complete Eighth Amendment appeal to SCOTUS. For instance, inmates can get to the court by filing a writ of habeas corpus. This essentially is a summons to force a court order. It basically demands that the prisoner be taken to court and that the prison warden or officials take the prisoner there. You cannot deny the prisoner access to the courts. The court can then decide whether or not the sentence is constitutional and whether the prison has the authority to keep the prisoner detained. Inmates can also file a Section 1983 lawsuit, which is used for the courts to address any civil rights violations that may have occurred while the inmate was incarcerated. They are making the argument that their civil rights have been violated either before their trial or their verdict or their sentence or at some point since they have been incarcerated. Finally, inmates can file a writ of mandamus, which means that the inmate has sued because a government official has either done something they shouldn't have or they didn't do something that they should have. For example, the correctional officers didn't put me into protective custody when they should have, and now I was attacked by the other inmates. I could sue for the ability to get back into protective custody when there is an order stating that I should be there. So let's go ahead and break these down just a little bit further. Habeas corpus is Latin for to have the body and is known as the Great Writ of Liberty. It can be found in Article 1, Section 9 of the U.S. Constitution, which states that the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion and public safety may require it. So this means that in regular peacetime, the writ stands and inmates can file an order for correctional authorities, being the respondent, to bring the defendant who requested filing the paperwork or the writ, meaning that they are the petitioner, to court. If they have evidence that they want to present, if they have an appeals argument that they want to be heard, or anything else that they feel is necessary for their case, the court has to hear it if the writ is filed properly. Habeas corpus, these are actually the most popular of the petitions that are filed in court. Habeas corpus cases largely have to do with the unconstitutionality of the inmate's conviction or sentence. The constitutionality issue might have to do with one of the following issues. First, ineffective defense counsel. This means that either my attorney didn't give me good legal advice or he or she wasn't prepared for the case. My public defender was overworked and they didn't give me my case the attention that I deserved. It's sort of the go-to rationale for habeas corpus cases. But you can also petition that there were errors made by the trial court. This means that something should have been entered into evidence, wasn't entered in, my attorney didn't get all of the necessary information available during the discovery process, or a key witness wasn't allowed to testify, perhaps. There can also be due process concerns. This means that maybe I wasn't properly Mirandized. I wasn't given an attorney when I requested one. There was no warrant for the search or seizure. The police lineup was botched, or maybe it was tampered with, things of this nature. Or I could have self-incrimination concerns. For instance, my confession might have been coerced by the police who had kept me detained for 20 hours with no food or water. I might not have said anything in other circumstances, but the officers were holding me for hours without access to food, water, or the bathroom, and I caved and confessed. As I said, these are the most popular petition that the court sees, nearly 60,000 a year in fact. That's a whole lot of writs that the court has to comb their way through in order to figure out which ones are legitimate and which ones are a result of boredom and having too much time on their hands. The majority of the writs come from state inmates. Because these lawsuits are so popular among inmates, there have been new regulations passed on in order to limit the frequency in which the court is flooded with these cases. The Anti-Terrorism and Effective Death Penalty Act of 1996 was put into place after the first World Trade Center bombings and the Oklahoma City bombing in the early 1990s. Like most laws, the main focus was not necessarily directed towards habeas corpus filings, but that portion was built into the law due to the amount of writs that were bogging the court down at the time. The new rule states that federal habeas corpus relief is only available when a state prisoner, if the petitioner has exhausted the remedies that are available at the state level, and there then has to be a 1-year period of limitation for any federal prisoners to file a motion attacking the illegality of their sentence. So this means that you get one shot a year to file this type of petition to the court in an attempt to alleviate the amount of suits that get processed each year. So let's go ahead and switch gears a little bit and turn our attention to the First Amendment. The First Amendment is one of the most important that we have. Prisoners are going to petition the government for a redress of grievances. It's a clause of the First Amendment that allows them to be able to appeal on constitutional grounds. We know that the First Amendment protects our freedom of religion, speech, press, and assembly, but those rights are often limited when you are a prison inmate. Basically, if your rights are not in direct violation with your status as a prisoner or with the goals of the prison, then you are protected. If they are in violation of one or both of those things, then the prison wins. This is what we call the balancing test. The jurist must weigh the importance of multiple factors in a case. There has to be a deeper consideration of issues than just the baseline grievance. You must balance the constitutional rights of the inmate against what is best for the prison as an institution in terms of safety of the inmates and the correctional officers in trying to avoid riots or just making sure that the prison is properly run without any incidents. This test was first established in Pell v. Procunior in 1974, in which the inmates in a California prison were prohibited by the California Department of Corrections from talking to the press, and the DOC actually forbid them from giving media interviews. The California DOC manual stated that press and other media interviews with specific individual inmates was not permitted. However, they had allowed interviews in the past, and it ended up badly for the prison. So the prison said no more interviews. Some of the interviews were taking place actually gave the inmates too much notoriety inside and outside of the prison. The inmates then filed suit saying that their First Amendment rights were being infringed upon. SCOTUS heard the case and came back and said no, they weren't being infringed upon. The prison actually has a legitimate reason for not allowing the inmates to talk to the media. They didn't want the prisoners to gain too much notoriety, for the prison to have a bad image, and they also wanted to keep everybody safe. So the balancing test was established. Embedded in the First Amendment is our freedom of religion, more specifically our freedom to practice religion without the prosecution from the government. This is very true on the outside. You can practice pretty much whatever you want as long as no one is being harassed or harmed while you engage in that practice. Things are a little bit different on the inside of prison. You still have the right to practice religion, but that comes with some limitations. In the case of Cooper v. Pate, the inmate in question, Mr. Cooper, was a black Muslim, and he wanted to be able to purchase religious publications that focused on Muslim teachings and that were being disseminated by the black Muslim movement. The prison officials at the Illinois State Prison refused and did not allow him to purchase those publications. Mr. Cooper then filed a case stating that Warren Pate was violating his First Amendment rights because other prisoners were allowed to purchase things like the Bible, but he was not allowed to purchase the Quran. He filed that he was being segregated and singled out. The prison replied that the black Muslim movement was controversial in the prison at the time, and it actually advocated for the overthrow of the white race. The court then ruled in favor of Mr. Pate, saying that he should not be denied the ability to purchase the Quran and other reading materials because Islam is a recognized faith, and this denial was in clear violation of the inmate's First Amendment rights. However, SCOTUS then also established a set standard that allows for inmates to be able to practice their chosen religion, provided that first, it has to be an established religion. Normally, they judge this whether or not individuals are practicing their religion outside of the prison. So the biggest religions are certainly recognized. Things like Christianity, Islam, Hinduism, Buddhism, or Judaism are all recognized religions with millions and sometimes billions of followers. So clearly, these are established. Second, the court ruled that the practices of the religion must conform to the tenets of the religion. So for example, if you declare yourself to be Christian or Muslim, for instance, you would then not be able to take part in Passover services or something of that nature, as Passover is not celebrated by either one of those religions. Third, the court stated that your religious practices cannot pose a security risk. Nothing that you do in trying to practice your religion can serve as a security risk or can disrupt prison operations. For example, if you are a Jewish inmate, you might not get to light a menorah because that is considered a threat that you could potentially set something on fire. This might be especially true in a non-smoking prison where you normally wouldn't have access to matches to begin with. In addition, the courts have ruled that you cannot jump religions. If you claim that you are of one faith, you cannot claim another faith because the food is better or because the inmates don't have to work on a specific religious holiday. Your book goes into significant detail regarding more cases that were filed based on these religious issues. Cases such as Cruz v. Beto, 1972, McCorkle v. Johnson, 1989, and Olone v. Shabazz in 1987 all ruled once again about the religious protections that both the inmates have and what would be in violation of the court's attempt to keep the prisoner safe. In addition to religion, we know that First Amendment protections extend to free speech, which then extends to letter writing and the mail. However, just like we cannot say anything we want to on the outside of prison, prisoners cannot say anything they want to inside of the prison. As you may or may not know, prison mail is screened by correctional officers in an attempt to get contraband from making its way inside the prison. You had folks trying to smuggle in contraband through the mail. It's common for them to try and cut out books to hide weapons, or drugs are being sent in via care packages or other ways. But part of that screening is to look for the content of the letters as well. So this means that prisoners have the right to send mail out, but they just can't write things and not expect prison officials to first review all outgoing and incoming pieces of mail. So in 1974, we see that in the case of Procunior v. Martinez, yes, that is indeed the same Procunior that we saw earlier in Pell v. Procunior, the case focuses on the letters that were being screened by the California DOC. In this case, inmates sued the corrections director for the California DOC because he was not allowing inmates to communicate with law students and paralegals about their cases. These were attorney-client interviews, and that conversation should be allowed to occur. However, in the correspondence, the DOC officials felt like inmates were magnifying issues that were taking place in the prison, and they were complaining about the prisons more than was actually necessary. So the DOC simply didn't send out the letters. But they also did not inform inmates that their letters were not being sent out. SCOTUS then said that the DOC must inform the inmates if the letters are not being sent out. They can still monitor the mail, but they cannot limit the free speech of inmates unless there is a legitimate reason to do so. There are two large issues that are taking place here. First is the order discipline issue that was present for religion as well. So for instance, if the letters are trying to plan another crime, or if they are trying to incite a riot, or if the package was trying to smuggle something into the prison, then that would be a reason for the COs to confiscate it. Secondly, if there was an issue of institutional security, this is sort of the same difference. I don't want you bringing anything into the prison that shouldn't be here, so don't go off and stab somebody with the weapon that was in the book that got through somehow. One of the other regulations that are facing prisoner communication focuses on the communication with other prisoners. Typically, they are not allowed to communicate with one another, with only a few exceptions. One being married couples and the other being family members. Parents can communicate with children and siblings can communicate with one another, but it wasn't until the Turner case in 1987 that the same protection was afforded to married spouses. As we spoke about before, there has to be an institutional reason for why the prison would want to intercept the mail of an inmate. In Thornburg v. Abbott in 1989, the court held that the prison regulations that permit the Federal Bureau of Prisons to reject incoming publications were found to be detrimental to institutional security are actually valid if they reasonably are related to a legitimate penological interest. So, this case applies to things like nude photographs and sexually explicit magazines and such. If your significant other sends you nude photographs of themselves or sends you pornographic material, then that will be confiscated. It also means that you cannot get a subscription to Playboy. All of the inmates would want it, and you would be fighting over the issues that are arriving, and that would just cause a huge safety concern. However, this case does state that other periodicals such as the Wall Street Journal can be let into the prison, but they have to come directly from the publisher themselves. So as we talk about mail and communication, one of the most important things to improve inmate morale is the ability to periodically visit with friends and family during visitation weekends. Although it is not practiced anymore, a lot of prisons used to have conjugal visit programs where inmates could engage in overnight visits, or at least they could engage in a few hours of a visit in which the inmate and their wife would have some privacy to themselves. We normally associate conjugal visits with sexual activity, and of course that is what would happen most often. However, there is not a constitutional right to conjugal visits. These are permitted at the state level, and not everyone does this type of program anymore. Conjugal visits were actually started in Mississippi in the early 1900s in the Jim Crow South. The warden of Parchman Farm, which is now known as Mississippi State Prison, actually began the practice of conjugal visits. He hoped that sex would compel the mostly black prisoner population to work harder on the prison's 1,600 acres of really rich Delta farmland. The warden allowed the prisoners time with spouses, or more often prostitutes, on Sundays only. White prisoners began participating in the 1940s. By the 1990s, as many as 17 states allowed for conjugal visit programs, but they all seemed to disappear as part of the Get Tough movement towards crime. Now, only a handful of states still allow for conjugal visits to actually occur, with Mississippi and New Mexico discontinuing their programs in 2014. For conjugal visits to be approved, you have to prove that you are married. A simple marriage license will do just fine. Some states will actually provide you with condoms, sheets for the bed, soap, and other toiletries, whereas other states require that the visitor bring all of those items. The visitor has to pass a background check. There has to be proof of marriage. The inmate and the visitor must be free of any STDs, and both the visitor and the inmate are searched before and after the visit to make sure that anything is not being smuggled into the prison. This is a contraband issue. This is a picture of the conjugal visit trailers that are used in upstate New York. Now same-sex partners are allowed to participate in conjugal visits there and in California as well. Look at how rudimentary these campers are. They're all just lined up within the confines of the prison. You might be able to stay in the camper overnight or just for a few hours depending on availability. You only get to have one visit per month. Some programs allow for just the spouse and others allow for you to have your children present as well. I know what you might be thinking, and it's kind of strange for an inmate to have his or her children present during one of these visits, but remember that this is simply a family visit. Sex is not an absolute, but what these visits do allow for is the inmate to reconnect with his family in whatever way is comfortable for them. To end the lecture today, I want to spend a few minutes discussing the death penalty and its use in this country in connection with the law. This is a very interesting time to speak about the Eighth Amendment and the cruel and unusual punishment clause, since we are now at a time where reviews are once again taking place. We will spend an entire chapter discussing the death penalty later this semester, but I want to take the time to focus on the legal circumstances surrounding it right now. We are a country that has always had the death penalty except for a very short period of time in the 1970s. But in the 1960s, there was a growing abolitionist movement that was taking place where people were growing very much against the death penalty. It was not being administered fairly across the board. There has been a history of botched executions that were being rushed, and later where people were being found innocent of the crime after they were executed. It was getting to the point where people were starting to abandon the use of the death penalty. It was very rarely used, even if people were currently on death row. Based on the growing resentment and the unfair application of the law, cases were reaching SCOTUS were being appealed based on Eighth Amendment violations. These cases resulted in SCOTUS overturning death penalty statutes and ruling the entire practice unconstitutional. The cases that I'm talking about here, Furman, Jackson, and Brock, are known collectively as the Furman decision. In this decision, the court's ruling basically said that states are not sentencing people to the death penalty in any sort of rational manner. All sorts of crimes would get the death penalty, regardless of whether or not someone committed a crime that actually resulted in a death. They ruled that the application of the death penalty was arbitrary and capricious. Minorities are receiving the death penalty a lot more frequently than whites. Minorities are being tried by all white juries. Minors are receiving the death penalty, and those with low IQs are receiving the death penalty as well. Basically, it was just a total free-for-all happening, and the court said that it needed to stop. So SCOTUS puts a moratorium on the use of the death penalty and stopped the practice immediately, essentially commuting everyone to life in prison and off of death row. However, SCOTUS did say that if you're going to continue to use the death penalty, that you need to figure out a better way to do it and take more factors into account, including aggravating and mitigating circumstances. Aggravating circumstances are anything that makes the offense worse and therefore deserving of the death penalty. For instance, did you kill a minor? Did you commit a sexual assault before you killed your victim? Did you kill multiple people? Or did you kill a police officer or an elderly person? Did you work with another person in the commission of the crime? These are all considered aggravating circumstances. Mitigating circumstances, on the other hand, are anything that makes the crime less severe and therefore undeserving of the death penalty. These factors include the defendant's age, mental health concerns or IQ levels, and a prior history of abuse. In order for the defendant to receive the death penalty, aggravating factors must outweigh mitigating factors. 4 years after the Furman decision, the states then appealed again to SCOTUS for the court to be able to review the new death penalty protocols that they had been implementing over the last 4 years. In the collective CRIJ decision, SCOTUS agrees to reinstate the death penalty, but requires states to implement the following things. First, they have to have bifurcated trials with death penalty eligible juries. This means that the guilty verdict is separate from whether or not the death penalty will be sought by the prosecution. So this means that they first have to get a guilty verdict for first degree or capital murder, and then they have to seek the death penalty. A death qualified jury means that everyone on the jury has to be at least willing to consider recommending the death penalty as a sentence for this particular defendant. If you have 1 or 2 jurors who are against the death penalty at all costs, you will never get a unanimous verdict. It does not mean that the death penalty has to be an absolute, just that the jurors are willing to consider it. Secondly, all inmates who are sentenced to the death penalty will get automatic appeals and a review of the conviction to make sure that this is an appropriate sentence for this particular individual. There's no going back when we talk about the death penalty. This is the irreversible punishment, so we have to make sure that we're correct so that we're not saying, oops, our bad, we're sorry we executed you later on. Finally, all defendants have to receive a proportionality review. Whether or not the death penalty was the appropriate sentence for the guy who was mentally handicapped, or the 14-year-old, or the defendant who didn't actually kill anybody. The court is looking to figure out whether or not the death penalty is appropriate for the crime that was committed in this particular case. As I said earlier, we will revisit the death penalty later in this semester, but this gives you a short preview of the sentence while still focusing on the law aspects surrounding that sentence. Today's uniting topic was the law and how it affects the correctional system. More specifically, we focused on the constitutional protections that are afforded to defendants and later inmates, and how those may differ compared to people who are not incarcerated. Remember that while inmates retain the same protections that we all have, they are not protected to the same extent. In the next lecture, we're going to turn our attention to sentencing defendants and how that's going to affect their time in prison. So meet me back here next time as we begin to explore Chapter 4.